Government has always been focused in developing business in India and desperately works on the policy of minimum government and maximum governance. With this viewpoint, Jan Vishwas Bill is presented. Jan Vishwas Bill, as the name suggests, means confidence in people. Government now, with the way of introducing this bill, intends to develop faith and confidence in its people. The bill does not come with a new law, but amends various existing laws. History shows that the sluggish growth of business in our country has been fear of getting imprisonment and hence not moving freely. While this bill now decriminalizes minor offences that would inspire greater confidence among the people and enhances their trust and results in ease of living and doing business. Jan Vishwas Bill has revised penalty of various offences and now rationalizes penalty with the gravity of offence. It also introduces a mechanism of increase of penalty every 3 years by 10%. This bill identifies few offences that were minor and resulted in imprisonment. So by way of introducing this bill, it also decriminalizes various minor offences, giving more trust and more confidence in people for doing business easily. Certain offences where the punishment was imprisonment or penalty or both is now proposed to be only punishable with fine, reducing the fear of doing business and avoiding the growth of business ecosystem. The bill also reduces the compliance burden by simplifying, digitizing and rationalizing them. Bill also takes care of country's judicial burden and overcrowding of prisoners by minimizing court interference, by adjudicating an administrative mechanism and endeavoring for ease of living and business easier. With this law, the government intends to decriminalize around 183 provisions of 42 laws across 19 ministries. Hi, I'm Falguni from Innovatree, and today we will be discussing about the proposed amendments in IP, that is intellectual property laws, in Jan Vishwas Bill. So the first proposal of amendment in relation with IP laws is done for Copyright Act 1957. So under section 68, there is a penalty for making false statement for the purpose of deceiving or influencing any authority or officer. And this is punishable by imprisonment or fine or both. The bill considers this as a minor offense and proposes this section to be omitted from the Copyright Act. Now let's jump to Patents Act 1970. So section 120 imposes fine to persons falsely representing that the product is patented in India and subject of patent application. The fine is limited to 1 lakh rupees. So considering the gravity of offence and wrongful practices, the bill proposes to increase the amount to 10 lakh and in case of continuation, rupees 1000 per day. Under section 121, if a person wrongfully uses the word patent office to show his place of business, he can be punished with imprisonment that can extend to 6 months or fine or both. This is now proposed to be omitted, considering this offence as a minor one. Section 122 imposes penalty to persons who refuses or fails to supply information requested by the controller, with fine that can extend to 10 lakh rupees. Considering the gravity of offence, the fine is now proposed to decrease by 1 lakh rupees and in case of continuation, fine of rupees 1000 per day. But in the second subsection, where the person furnishes false information or document, is punishable with imprisonment that may extend to 6 months or fine or both. This is now proposed to be high fine but not imprisonment, and the fine is not less than 25 lakh rupees. Under Section 123 of this Act, if a person practicing as a patent agent who is not a registered patent agent is punishable with 1 lakh rupees for the first instance and with 5 lakh in the case of second or subsequent offence. The bill proposes to increase the fine by 5 lakh and in case of continuation, rupees 1000 per day. There is an addition of provision in Section 124 of the bill, in which the bill proposes to provide power to the controller to impose penalty for defaults. Controller is also required to give hearing opportunity before imposing penalty. And in case of non-compliance of the order within 90 days, then the person can be punished with imprisonment that can extend to 1 year and fine that can range from rupees 25,000 and extend till 5 lakh rupees. The bill also proposes an addition under Section 159 that gives power to central government to make rules. So now coming to Trademarks Act 1999, removing of piece goods under Section 106 of the Act can be punishable with a fine up to rupees 1000. Considering this as a minor offence, the bill proposes to omit this section. Penalty under Section 107 for falsely representing a trademark as registered is punishable with imprisonment that may extend to 3 years or with fine or both. The bill proposes to remove imprisonment and fine starting rupees 25,000 and can go up to 1 lakh rupees. As in patents, same is the case in trademark. Falsely representing trademark office as its place of business under Section 108 is punishable with imprisonment that can extend up to 2 years or with fine or both. This is proposed to be omitted through this bill. Section 109 imposes penalty for causing false entry in the register with imprisonment that can extend up to 2 years or with fine or both. This is also proposed to be omitted, considering this as a minor offence. Bill proposes an addition of Section 112A, similarly to Patents Act, where registrar is giving power to impose penalty for any default, and registrar is required to give hearing opportunity before imposing any penalty. And in case of non-compliance of the order within 90 days, then the person can be punished with imprisonment that can extend to 1 year and fine of 1 lakh rupees. Section 140, subsection 3, where importers are asked to provide information on false trademark, and in case of failure, importer is fined by rupees 500. This is now proposed to be 10,000 rupees with a time limit of 14 days to provide such information. Bill also provides power to impose penalty through the Customs Act. The bill also proposes an addition of Section 157 to give power to the central government to make rules. So now let's discuss about the amendments proposed under Geographical Indication Act. So as we saw in patents and trademarks, the GI the bill proposes to add Section 37A as a provision to give power to registrar to impose penalty in case of default. Registrar is also required to give opportunity to be heard before imposing penalty, and non-compliance of the order within 90 days. This will be punishable with imprisonment extended up to 1 year or a fine starting rupees 25,000 extending up to 5 lakh rupees or both. Section 42, which imposes penalty for imprisonment which can extend to 3 years or with fine or both to any person on falsely representing a GI as registered. The bill considers this as an offence not fit for imprisonment as a punishment, so proposes to impose only monetary penalty from rupees 25,000 extending up to 1 lakh rupees. On the other hand, the bill also proposes to omit Section 43, which imposes penalty for improperly describing a place of business as connected with Geographical Indications Registry, and Section 44, which also imposes penalty for falsification of entries in the register, considering this as a minor offence. Lastly, the bill also proposes an addition of Clause OA in Section 87 that says that central government has power to make rules and carry out the provisions under this Act. That's all about this bill. Should you have any questions or concerns, you can reach out to us at the given details. Thank you.